Beyond estate planning basics, protecting assets, and especially protecting assets against long-term care costs and Medicaid spend down. Hi, my name is Lynn St. Louis, and I am the founder of Elder Law Group, ELG Estate Planning. We have offices in Spokane, Tri-Cities, and Seattle. One of our areas of expertise is Medicaid strategies. And as a result of that, our estate planning documents incorporate provisions that are not commonly found in traditional estate planning documents. So we're going to talk about that today. So in order to understand how your estate planning documents can protect assets, especially for your spouse following your death, we need to understand a little bit more about the basics. So I promise you, we are going to get to the beyond part and how to protect assets. But first, I just want to very briefly cover, and we won't take much time on this, the estate planning essential documents. So here I'm sharing my screen, and hopefully you are seeing the ELG Estate Planning, and we are simply talking about the basic documents. Now, these over on this side, I call the living documents. Those are durable powers of attorney for finances and for health, and then your healthcare directive. These documents protect you while you're alive so that the court isn't involved in your affairs. You want your powers of attorney to be durable, meaning if you lose capacity, your document carries on. You can have your power of attorney effective immediately or upon your incapacity. As an elder law attorney, we recommend immediately. It's far easier to have your trusted person act on your behalf if they don't have to get the doctor's support. A lot of people are reluctant for that. That's something you talk about with your attorney. If you're appointing somebody to act on your behalf, it works far better if it's an immediately effective document. And don't just name one person, name successors. Estate planning is all about planning for what happens in life, and you have to have contingency plans. The nice thing about durable powers of attorney for finance and for healthcare is it avoids a court-ordered guardianship or conservatorship if you don't have the durable power of attorney document. Keep the court out of your affairs if there's no good reason for them to be in your affairs. Now, we have this separated out for financial and for healthcare. You can have one durable power of attorney document that combines both. We find it works better if we separate them out. The reason for that is perhaps you want one person to be your financial power of attorney. Maybe you want somebody else to be your healthcare agent, your healthcare power of attorney. Also, the documents we prepare are fairly comprehensive, and some of the language doesn't have to be in the financial, that has to be in the healthcare, and vice versa. So it just makes sense to have them as separate. But if you have one that's a combined one, it may be perfectly appropriate. One of the things that's really important to understand with the powers of attorney is, do they include critical authority for Medicaid planning, for example? If you're not working with an elder law attorney, I can pretty much tell you, you don't have Medicaid critical authority in your power of attorney. Such things as you can revoke, your power of attorney can revoke a community property agreement. They can enter into a separate property agreement. They can do gifting, gifting of assets beyond the $19,000 exclusion amount, and gifting of assets that are not in exact compliance with your will, for example. So there's a lot of reasons that we want this authority. It is to protect assets. That's the kind of authority we want to see in powers of attorney. Your healthcare power of attorney really has very little to do with protecting assets. It's more to have somebody who will be your voice to speak as to your advance directive. It's also called a healthcare directive, living will so that they can be your voice when you don't have a voice because you can't speak for yourself because of some medical condition or advanced dementia or some reason. All the things we don't want to think about, but having all these documents in place make sure that your voice will be protected and that your care will be guided, your finances will be done by somebody that you trust. So those are your living documents. Now we're going to give you context about what happens upon your death. On this side of the page are what I call your dispositive documents. This is your revocable living trust or your will or your and your non-probate assets. So a lot of people have heard that a revocable living trust is the best way to go. It really depends on the state that you live in. In Washington state, oftentimes it's not a very good planning device, and we'll show you why in a moment. One of the reasons people like revocable living trusts is that if set up and managed correctly, it avoids probate, which if there's no good reason for a probate, makes sense to avoid it. But I will be showing you a good reason to do a probate and why a revocable living trust doesn't give you planning protections that can be very important to you, your spouse, your family, your assets. A revocable living trust does require ongoing lifetime maintenance, so you sign it when you sign all your other estate planning documents, and then you need to make sure you maintain that trust. Your bank accounts need to be in the trust. You buy a new house, it has to be in the trust. Anything you can put in the trust, basically you do. You retitle into the name of the trust, and as life goes on, more assets come in. Whatever the case is, you have to maintain that. If you do not maintain your trust, what happens is you're not going to avoid probate because a revocable living trust only reaches the assets that are within it. So if you have a revocable living trust, you know you also have a will. It's called a pour over will frequently. What that means is, oh, you forgot to put assets in your trust. Well, then there will be a probate to capture that asset, those assets, that will put them in the trust where they should have been all along. So not uncommonly with a trust administration, there is also a probate. That's not how it's intended to work, but that's how it does commonly work. Because of some orphaned asset, there also needs to be a probate. And what I want to point out, and I'll show you in detail, is that yes, the trust provides, if it's optimally done, no probate. It gives guidance for the trustee, be it you or a successor trustee, how to manage your finances. It doesn't give you any creditor protection. So if somebody in the state of Washington says your revocable living trust, your RLT gives you creditor protections, ask what protections. If you have an RLT, you know you didn't need to get a tax ID number. It's revocable, not irrevocable. You're the grantor, the trustor, the trustee, the beneficiary. It's all wrapped into one. When that's the situation, there are no creditor protections. Anybody that tells you there are protections, you need to ask more questions. Maybe they say it's an irrevocable trust, or maybe they'll say, oh, this is a trust under Cayman Islands law or something. I don't know. But a Washington RLT, revocable living trust, will not give you, as the grantor of that trust, any protections at all, period. And really importantly, this revocable living trust won't give your spouse any long-term care cost Medicaid type protections when you're gone. So you might think that yes, when I'm gone, I can protect all these assets for my spouse against the requirement of Medicaid spend down. You cannot do that with a revocable living trust. I will show you in a moment. Now, a will is the other very common dispositive instrument, dispositive plan. Everybody knows what a will is. You sign it, you declare who your family is, where you want your assets to go, and then on your passing, there must be a probate. Your original will is filed with the county where you reside in the Superior Court. Your personal representative is appointed to carry out your wishes as you put in your will. Any legitimate creditors are paid off. Then the assets are distributed to your beneficiaries. Then the probate is closed. The nice thing about probates in Washington is that if this is an estate where the assets exceed the debts, it is what's called a non-intervention probate. Non-intervention is a great thing to have. It means the court is not involved. They're involved in you filed the petition, they signed the order, they said, yes, this is a valid will, gave the personal representative their letters testamentary so they can go off and do what they need to do, but they're not involved thereafter. It's a fairly easy process. When I say easy process, I didn't say inexpensive, but I do say it's a fairly easy process. But whenever you're involving lawyers, unless you're going to do it yourself, which is very difficult. Whenever you're involving lawyers, legal fees will build up. So we do have people that do it themselves, probate, and then they come in and ask for some help. But I get it. The thing about a will is that it does protect assets against Medicaid spend out. It can create any kind of a trust, like for any beneficiary, but particularly for your surviving spouse. There is an asset protection supplemental needs trust option that protects assets for that person, for your spouse. So I would be remiss if I didn't talk about non-probate assets. Non-probate assets, what are they? If you own a bank account and it's titled jointly with right of survivorship with somebody else, it's probably a non-probate asset. It's not in the name of your trust. It says on your death it goes to the surviving owner, so it's not going to go through your will. Be aware of that. Beneficiary designations or pay on death provisions. You can have your bank account pay on death. You can have your life insurance with a beneficiary designation, your 401k, your IRA. All of those things are non-probate, non-trust assets because they pay according to whatever it says on the pay on death direction. There can be transfer on death deeds. You can transfer your house on your death to go wherever you want it to go. You just have to file the transfer on death deed before you die. And then there's also property status or community property agreements that can be used to clarify whether property is community or whether it's separate, and even to avoid probate. In fact, with all these non-probate assets, if you're working with an estate planning lawyer, and there's no good reason for you to have a probate, they will be recommending ways to set up your estate to avoid a probate. You will always have a will because that is kind of the safeguard to capture anything. But it could be that you have a will, but your estate plan is set up to avoid probate. And that's not uncommon. The reason we set up estates to avoid probate is there's no benefit to a probate. Don't do a probate. Then you might say, well, how about we have a revocable living trust? That's a lot of extra cost and work throughout your lifetime. Why do you need a revocable living trust if you can simply set up all your assets to pass on your death automatically? That makes sense. So I'm just going to check and make sure, see if we have any questions yet before I move on to the fun stuff. All right. Remember, you can put your questions and answers into the question and answer if you're joining me live, and I will try to answer them as we go forward. So let's talk about what I call the fun stuff, and that is asset protection estate planning. So the best way to understand this is to use a set of facts. So what we have in this case is Betty and Fred. They have $1 million estate made up of their house and of their investments. Poor Betty got Alzheimer's. They met with their estate planning and elder law attorney. and made sure they had in place the right estate plan for them. Now, whenever we are working with retirees who have a diagnosis of Alzheimer's or other disease process that suggests likely long-term care, we are probably going to recommend this kind of a trust because we don't know what life is going to bring, except for we do pretty well know that there's going to be long-term care costs in this couple's future. So not uncommonly what happens when one has dementia and the other doesn't, the well spouse takes care of the ill spouse. And that's what's happened here. Fred and Betty live in their own home. Fred provides the support that Betty needs. If Betty didn't have Fred's support, she could not live at home. She would be a danger to herself. And then, not uncommonly, what happens, and in this scenario, as you can see, Fred passes. Now what's going to happen? Well, as I mentioned, they have the right kind of estate plan. They don't have a revocable living trust. They have a will with an asset protection supplemental needs trust. So with $1 million estate, when Fred passes, his one half of this estate, or $500,000, will pass through his will, through the probate process, into this special trust for Betty. Now, why is that important? The $500,000 that is in that asset protection trust does not count as Betty's because it isn't hers. It is not owned by her. She still has her own one half of this couple's estate, or $500,000, but she doesn't have Fred's share because that went into a trust. And this trust will be honored by the state of Washington, by the Department of Social and Health Services and its Home and Community Services Department. Nothing in that trust will be counted against Betty should she ever need Medicaid in the future. We know she's going to need long-term care. We know that she's going to need help finding a facility-based care, and that facility-based care may have a private pay requirement that's going to take some of Betty's money. Everything depends on what her care needs are, where she lives. There's a lot of unknowns in this example here. What is known, however, is that $500,000 is protected, and Betty, no matter what happens with her half of the money, she will never become impoverished because that money is always protected for her. And then on her death, that $500,000 or whatever might be left of it goes to, for example, the couple's 2 kids or whatever. So it's, another benefit of this is that there will be money left for the kids. Though that's usually not the primary planning purpose. The primary planning purpose is to ensure that the spouses aren't going to be impoverished, that there will be money that does not have to be spent down for Medicaid. We just finished talking about this 50% asset protection. I want you to know that there is an opportunity for 100% asset protection. And how is that? We live in Washington. Washington is a community property state. For the most part, that makes us think everything is owned half-half. But there is a planning opportunity if one of the spouses is going to pass imminently. Maybe we want to move all the assets of this couple over to the ill spouse. I know this is counterintuitive. Move everything over to the ill spouse. So Fred will be passing. So Betty, or since we know Betty has Alzheimer's, it's going to be through her attorney in fact on her financial durable power of attorney, is going to say, Fred is ill. We think he's going to pass. We want to move all assets over to his name. We can do that through what's called a separate property agreement, which says, Betty says, I give everything to Fred, and then in the agreement, everything becomes Fred's. Betty owns zero. The reason that we do that is we know Betty is the one that needs care. Betty has Alzheimer's. Fred is going to pass soon. So on Fred's passing, we don't get just 50% asset protection. We get 100%, or in this case, $1 million of asset protection, meaning that everything this couple owned was Fred's when he died. It all goes through the probate, through his will, into this asset protection trust for Betty's benefit. As a result, she is immediately eligible for Medicaid long-term care benefits, even though there's $1 million set aside in a trust for her. Sometimes people go, well, isn't there a 5-year look back? There is for third parties, but there's not a 5-year look back between spouses. If you want to look this up, I encourage you to do so. Sometimes people say, well, can't I just do that through a revocable living trust and avoid a probate because probates are going to cost a lot of money? I'll come back to this. Let's say this probate costs $10,000. Okay. We've protected either $500,000 or $1 million. If instead this couple had a revocable living trust, so they don't have to go through probate, they have protected $0. Zero. There will not be Medicaid eligibility for Betty until she goes through the $1 million, basically. So this asset protection for the surviving spouse can only be accomplished through a will and through a probate. That's the Washington Administrative Code site 182-516-0130. That's WAC, W-A-C, 182-516-0130. So I think it's really important that people understand that sometimes a revocable living trust can end up costing them far beyond what they invested in the trust, far beyond the maintenance of the trust, but actually up to the entirety of the couple's estate, at least when it comes to long-term care costs and Medicaid eligibility. If that's not an issue, then a revocable living trust might be a perfectly appropriate planning tool. But if it is an issue, and if you're working with an attorney that says, oh no, a revocable living trust can give those protections, just like I explained to you, you need to ask more questions, because the answer to that is the trust doesn't. But what we do is we have the trust pay to the estate, and then it goes through the estate, through the will, and creates this trust like I just explained. Well, then why do you have a revocable living trust if your estate plan is set up to go through a will? I believe it is disingenuous, to say the best. Let me see if we have any questions here. What do you do if more than one of your kids thinks that they should be a decision maker? Well, it's up to you to choose and choose successor levels. Think about the child who you think is the most responsible and the most capable of handling your financial affairs. Think of the child who is best in talking with your doctors, is decisive, is reasonable, won't lose it. And then talk with them about, both of you are capable or whatever. And then say, but this is the order that I think will work best. Sometimes location has something to do with it. Sometimes availability, the child's availability of time has something to do with it. But we strongly encourage you to name one and then the other in a successor order. Don't do joint decision makers. That really creates problems. And in fact, sometimes causes this whole plan to fall apart, and then you end up in a guardianship, and I have seen that before. So it really is, take your time, have a discussion with the kids, but ultimately you're the one that knows what's right. And don't follow the eldest has to do this. No, you're looking at capabilities, and we all know our kids have very different strengths and capabilities. Another question, do you need to have a trust and a will in a good estate plan? If you have a trust, you need a will. Having a trust and a will does not mean you have a good estate plan. If you have concerns regarding long-term care costs for your spouse, a revocable living trust and a will is a bad estate plan. That's about all the most definitive I can get, because in estate planning, what's really important is all about looking at what your situation is. Oh, let me back up from that. Do you have lifetime long-term care insurance? Then maybe a revocable living trust and a will is a good idea, because you're never going to rely on state benefits, even if you had $1 million in your trust, because your long-term care insurance will pay for the rest of your life. We don't see those very commonly anymore. They don't sell long-term care life insurance. I mean, forever insurance pays for your whole life anymore. That's one possibility. But generally speaking, a revocable living trust is not a good estate planning tool if long-term care expenses are a concern of yours. A will is a much better planning tool. They're great questions. If Betty has dementia, is she deemed capable of making this change when Fred's death is imminent? Fantastic question. That is why the answer is likely no. So if I'm sharing my screen again, because Fred's death is imminent, Betty, through her attorney, in fact, gives everything over to Fred. Right? Betty has dementia. She is not capable of making decisions. But fortunately, Fred and Betty got their asset protection estate planning done in advance of her losing capacity. And because of that, they had the right durable powers of attorney for finances in place, which means that it included critical authority for separate property, revoking any community property and making it separate. So because of that, we were able to transfer the assets. Great question. And I will give a shout out for Active Living Expo that is coming up in April. Colleen, if you would put that in so that people know what the date is. I will actually be speaking at the Active Living Expo, going through a very similar presentation, because always the audience participation and the questions make it a little bit different, with a lot of good questions, but we will be covering this type of discussion then. Yeah, it'll be available. You'll get the one pager, and you can go to the Active Living Expo too. All right. Well, I am not seeing any more questions. I want to thank you for sharing your valuable time with me today. I hope that there are some good takeaways. When you see this on YouTube, give us a like, give us a thumbs up, subscribe to our channel. And most importantly, and what's really important to me, is share this information with people who might not know about the benefits of asset protection estate planning, particularly in the state of Washington. So reach out to us at Elder Law Group, ELG Estate Planning. We're at www.elgwa.com. Our phone number is 509-468-0551. Again, thanks for joining me. Have a fantastic day. Bye-bye.